Hello, and thank you for joining Wisconsin Parkinson Association's educational video series. I'm Jeremy Otte, Director of Outreach and Education with Wisconsin Parkinson Association. WPA provides hope, community, support, and resources for people with Parkinson's disease and their loved ones. Today, we're going to talk with Joanne Leifheit, an attorney with Joanne Leifheit, LLC. She will discuss with us estate planning and a number of other legal issues and concerns that you would want to consider. Welcome, Joanne. Thanks for joining us today.
Thank you very much for having me, Jeremy. I'm glad to be here.
Well, we're happy to have you. You want to tell us a little bit about your background and about your law firm?
Sure. I've practiced for over 23 years. I'm licensed in Wisconsin. I'm also licensed in Illinois, but I'm inactive there. My practice is focused solely in Wisconsin. My firm is an elder law firm, and we cover estate planning for all ages, probate matters, trust administration matters. We also assist persons with disabilities with their estate planning through what are called special needs trusts. And also we assist families who have family members who may have a disability with special needs trusts. We handle adult guardianships, wills, trusts, power of attorney, anything under the umbrella of elder law. I've been a solo practitioner for 15 years out of my practice. However, about a year ago, I brought on another attorney, and I have 4 staff members in total. We're located in Pewaukee, north of the Machine Shed restaurant. And one of the things we pride ourselves on is education. And in my office, about once a week, we offer small informal gatherings for anyone who wants to come and learn general concepts about estate planning, just like you and I are going to discuss today.
Thanks for sharing all that. I think what we'll do, since you mentioned educational classes, do you have a website that they can find those classes and times? I know you probably have had to change a few things with COVID-19 right now, but where would they go to find those if they're interested in joining those after they listen to today's discussion?
Sure. The easiest way might be to call the office because we can give you the upcoming workshop dates. And due to the virus, we are limiting the workshop to very small groups so that we can have a nice amount of social distancing. And the number here is 262-347-2820. There's no charge for the workshops, and as an added bonus, we serve pie at the workshop. So feel free to come yourself, Jeremy.
Right. Who doesn't love pie? I mean, come on. So in your introduction, Joanne, you talked about a lot of the stuff we're going to touch on today. I think the first thing we're going to jump into, because it's kind of something we hear a lot about, but I don't know if everybody understands what it is what exactly is estate planning and what does that mean?
So I think we probably want to start with the term estate, and I'm often asked, Joanne, what does estate mean? So estate means anything that we may have of value, and we're typically talking about monetary value. We may have a life insurance policy, a 401k, we might have a Roth IRA, accounts at a bank, such as a checking, a savings, money market, CD. Most of us have a large investment in our home. So we may own real estate, or maybe even have 2 parcels of land, perhaps a piece of hunting land up north or somewhere down south where we can get away from the Wisconsin winters. So essentially anything that we own of value is considered part of our estate. We're typically talking about monetary value. However, we can be talking about sentimental value items also. For example, a family Bible that's being passed down through generations. I myself have a small desk from our family farmhouse that means a lot to me, and I wouldn't necessarily be able to sell it for much, but it's part of my estate because I care about it and I want to take care of it. So that's an estate means anything that we have of any kind of value. Estate planning means that we have goals around whatever we have of value, and we really want to control what's going to happen to those items after we pass on, and who's going to inherit and how they're going to inherit. And during our lifetime, we also want to make sure that if we can't fully be in control of our estate, that we're naming someone who can be. So it's really about comprehensive planning for what we have of value, both during our lifetime and after death, as we pass our worth and our valuable items on to others.
So when you describe estate planning, it sounds to the layperson, me, a lot like a will. So can we touch on how estate planning and a will are similar, but also very different?
So with estate planning, every client has several options, and so you can make choices about how you want your estate plan to be structured. A will is probably the most common and well-known method of estate planning, but there are other methods. Clients can utilize wills. They can also use trusts, and there are other methods such as relying heavily on beneficiary designations, joint account ownership, and those forms. So estate planning methods involve not only determining what your goals are, for example, what do you want to see happen to your estate after death, but it's also about choosing the method that fits you best legally and personally. So it's a process, in other words.
It's a process. I think one of the things I hear a lot, we should probably start the process a lot sooner than most of us do. So from the attorney perspective, when's the right time to really start thinking about your estate and will versus when most people actually probably do it?
Anytime, really. Once we reach adulthood, we have the ability to control anything that we own. I typically see most of my clients in their 40s, 50s, 60s, and on up. Sometimes even with the on up, clients are coming in for the first time. But I also have worked with 18-year-olds. I've worked with newly married couples. I've worked with newly married couples having their first child. However, estate planning can really begin at any time as well. It should.
And I appreciate that. I think you always hear it's never too early to start. And I think some people always wait. Well, I don't have a lot to put into it. Let's start now, because then you can add stuff, not wait until you have a bunch and maybe it's too late. So kind of jumping off of estate planning and wills, you and I have talked before about, power of attorney. And there's a difference between healthcare power of attorney and financial power of attorney. And I think people just use power of attorney as a catch-all. Can you explain the difference between the two and why it's important to probably have both of those?
Sure. So one thing as a starting point to remember about powers of attorney is that these are documents that apply to us during our lifetime. So all of us are able to manage our own affairs, including health and finances, unless we are under an incapacity, medical incapacity, mental incapacity. So a healthcare power of attorney is going to allow us to name someone else. Legally, we call that person an agent, to step in and essentially step into our shoes and make our healthcare decisions for us if we are unable to make those decisions. Likewise, if we're under some type of health or medical issue that renders us as having an incapacity, it's unlikely we're going to be able to handle the financial aspects of our life also, getting that mortgage bill paid, signing that tax return, finishing up a closing on a house. So we want the companion document, which is called a financial power of attorney, at the same time. I find that almost everyone I speak with is familiar with healthcare powers of attorney, because healthcare providers, if they're accepting any federal funds, are required to now tell their clients and patients about healthcare documents. But I want to make sure that the public learns that you really need the companion document, which is a financial power of attorney, because we don't want to leave that an aspect of your life that's unaddressed by not having the proper legal document. And by the way, these documents allow us, to the extent we're able to make choices about what we want and who we're telling that to and who is actually stepping in and making the decisions for us. In the absence of powers of attorney, we may end up the subject of a court proceeding called a guardianship proceeding, where what can happen and who can be appointed on our behalf is now out of our control. So powers of attorney give us as much control as possible under some very difficult circumstances.
For power of attorney, whether health or financial, does it have to be a relative? Can it be a friend, a trusted confidant, like an attorney? Does it, who could it be?
Absolutely. Oftentimes, as you mentioned, the agents named in powers of attorney are family members. However, you can also choose friends. You might also choose an attorney. That would be a little rare, and your own attorney, in my opinion, should not be serving, absolutely should not be serving. That's a conflict of interest. There are banks and organizations such as social service organizations who will sometimes step in and handle various aspects of estate planning, including serving as trustee, executor, on occasion, a financial power of attorney agent. It's a little harder to find someone to serve as a healthcare power of attorney agent. If you can't turn to a family member or a friend, that can get a bit challenging sometimes. But the most important thing, in my opinion, is that you really have to have trust in the person you're naming, that they're going to be a good advocate for you, and follow the instructions that you would want. So you want a highly trustworthy person who's going to be the best advocate that they can be for you.
I want to touch on that, Joanne. I think you hit two really important things that people don't always consider: somebody you trust and somebody who can be a great advocate for you. Yeah. I think I see a lot of time in families, we just pick the oldest child because, well, they're the oldest. Once in a while, that may not be the right option based on the trust and advocate comment. And I think that's very important to highlight when you mention it like that. One of the other things I see, and maybe you see from the attorney perspective, a lot of people kind of push off the estate planning, the will, the power of attorney, because we don't want to talk about death. And one of the things I've run into on a personal level and professionally is we will assign our healthcare power of attorney, but we won't talk to them about our advanced directive plans. So when you talk to a family that's really, maybe going through this process, what are the things you really recommend they consider when they're taking on that mantle of healthcare power of attorney?
Well, communication is key, and ideally that communication should occur while everyone is healthy and able to have the conversation. So I encourage my families to open up this discussion and share the healthcare power of attorney documents. There are healthcare questionnaires that can help you envision scenarios and convey your wishes as to how you'd like your medical care to go and to happen under various scenarios. So communication as much as possible is key. Ideally, that's one-on-one, verbally or orally, but wishes can also be communicated in writing. Particularly, we can incorporate various wishes into the healthcare power of attorney document itself. So I think that it's partially a generational thing in my experience. Some of the generations, maybe 2 or more generations older than us, may have felt that these things should not be discussed, but actually the opposite is true. And you can help yourself and help your family know what you want when there's as much communication as there can possibly be revolving around the documentation.
Well, I think you've echoed everything I've ever heard about advanced directives power of attorney. It's communication. It's having that uncomfortable conversation that, hey, if something happens, here's my wishes. Here's how I want to take it. I mean, I know I've seen, again, personally and professionally, the person with the health issue is much more prepared to go than the family's willing to let them go. So having that open, honest communication and saying, hey, I don't want a whole lot of heroic measures taken. When it's my time, it's my time. And I think you just echoed that, so I appreciate that. So you mentioned a little bit trust earlier. Let's start with a revocable living trust. Can you explain a little bit what that is? And then I think we'll touch on some of the other trusts that are out there that people may be interested in.
Oh, absolutely. So, and this is probably one of the most common questions that I'm asked, what really is a trust and how does it work? So just like a will, a trust is a legal document, and wills and trusts have many similarities. In both documents, the drafter is nominating a person, usually a person, that they want to administer their estate after death. They have, clients have goals, they have directions written in these documents about their goals. And so in both a will and a trust, you are going to nominate someone to administer your estate and follow through with your goals from start to finish. In a will, we call that person an executor or a personal representative. In a trust, that person is called a trustee. More technically, they're called a successor trustee. So the one thing in common is that someone is administering your estate plan. The other thing that wills and trusts have in common is that we are able to draft out in great detail what you want to see happen. Perhaps it's having nieces and nephews' education paid for. Perhaps it's taking care of a family member with a disability. Perhaps you're concerned about the longevity of a child's marriage, and you're hoping to protect that child's inheritance so that we are reducing risk that that inheritance is going to go 50% to a future ex-spouse. So details are drafted in the estate plan, whether it's a will or a trust. What the true difference is essentially between these documents is that after a death, a will is administered through the court proceedings. That's called the probate process. Trusts are administered without court. They are administered in a more private manner. So the successor trustee can essentially take control and administer the estate without having to do that under court supervision. So some of my clients choose to avoid that court process, and they choose the privacy that comes along with the court process, or with the privacy that comes along with not being in that court process. One thing I'll add, Jeremy, is that the probate process in and of itself is not a bad system, but it can take a while to get through it. It can potentially be expensive depending on how things happen. But again, it's not a bad system. It's just that I have many clients who choose to avoid the system entirely and have their affairs remain in more of a private nature.
And I can see value in that, trying to keep it private and respecting people's privacy, and the fact they have the option. I can see a lot of people would take that. Like you said, it's no knock on the system. It's just that maybe the way people want to do it. They're private people and want to keep it that way.
Yeah.
We talked a little bit about revocable living. What about a special needs trust? What is that, and what are the really information I would need to know if I'm considering that for a loved one?
So persons with a disability may often or may in the future be receiving public benefits. And some of those public benefit programs are what we call needs-based, meaning that the person with the disability has to qualify to receive the benefit. And part of that qualification is a financial qualification. Essentially, the assets have to be really limited before a person can receive a needs-based public benefit. And if a person comes into money through an inheritance or a personal injury settlement, what can happen is if they are currently on or will be on in the future needs-based public benefits, they may be disqualified because now their asset base is too high. So then they can only then solely rely on the money that they've inherited or received, which is fine. However, by utilizing a special needs trust, a person with a disability can not only receive money and use that money, but also remain on public benefits. So it's getting the best of both worlds. The public benefits programs are challenging to get into and challenging to stay in. And so if we don't have to go on and in and out of these programs, it's removes a lot of work and stress off of a person or a family who has a disabled family member. So special needs trust can be used to allow the person to remain on the needs-based public benefits and also draw upon and utilize an inheritance or a sum of money for their own benefit. The special needs trusts are really great tools for persons with a disability under these circumstances.
If I'm setting up a special needs trust because a loved one has a disability, can we draw on that while I'm still alive? Or is that something that I have to pass away for the trust to kick in for them to draw on for support and financing?
I would say you may get a different answer from attorneys depending on their practice and their philosophy. Most of the clients who are coming to see me are really thinking about, how am I going to take care of my child after death? So it's not that money can't be placed in a special needs trust, and it's not that it can't be used for the person with the disability during their lifetime. However, once money is sent into a special needs trust, under most circumstances, it becomes a decision that cannot be changed. So we typically allow the money to flow into that trust after a death. That would be the most typical scenario that my clients are faced with. A more typical scenario where a person is placing money in a special needs trust and using it during their lifetime is when a special needs trust is set up by the person with a disability themselves. In other words, the money is going to hit their checkbook. And that can happen in a couple of ways. If, for example, there's a personal injury settlement, the only person who can receive the payout is the person with the disability, so the money's theirs. If a person with a disability receives an inheritance and the person who died did not preemptively set up a special needs trust, now that inheritance is going to technically hit the checkbook of the person with the disability. So one of the nice features about special needs trust is that if such a person is inheriting or receiving money, he or she can establish their own special needs trust and use the funds during their lifetime while remaining on public benefits. So the flip side of that would be a person who wants to establish a what we call a third-party trust for another person with a disability, but mainly that takes effect after death.
I appreciate that. That's a good explanation. I'm with you. Most of the people I see, it's once I pass, who's going to take care of my adult child? But there are those circumstances where maybe the child lives somewhere else with family and you still want to provide support. So it's good to know you have options within that. You just talked a little bit about public benefits, which makes me think a little bit about Medicaid. How does Medicaid impact estate planning, trusts, wills, all that information, if it does at all? But what are the things you look at with Medicaid when working with individuals?
Well, it's interesting when you're combining the topic of estate planning with Medicaid. They're both topics that have a lot of depth, and they are both very involved, and they operate under different rules. Estate planning is typically going to operate under state law principles. Medicaid is a federally based program, so often we're tapping into a complex set of federal laws combined with state statutes. So when we are talking about these two topics at the same time, it can be in many scenarios. I could be, for example, talking to a married couple about what's going to happen if one or both of them need skilled care. So their goal might be to complete their estate planning, but they also have a dual concern, which is long-term care going to eat up most of our estate anyway? So we are often combining the topics. It's a bit challenging because they're both involved topics and they operate under different rules. But that's one scenario where I might be discussing both topics. Special needs trusts are a topic where we often have the duality also, because one of the needs-based public benefits programs that is most often used is Medicaid through the state. So we are often discussing how to allow someone to go on or remain on Medicaid if they're going to receive a sum of money. And that's where we start talking about the special needs trust. So it's complex, Jeremy, and there's a lot to it, and it appears in various different scenarios in relation to estate planning.
Yeah, and I think, if anybody expects us to cover it all in 30 minutes, they're probably barking up the wrong tree, because I think you're right. Medicaid in and of itself could probably be an hour to an hour and a half presentation. So I think that's definitely a concern. But I think you've given us a good overview of it to some degree. When it does come to running into Medicaid, I think the one I always hear, and maybe you can just touch on briefly because it is a really long one, people are always worried about that 5-year look back period. Mm-hmm. Can you explain a little bit what that is and maybe how that impacts individuals when they are looking at, and I think of the Parkinson population, Joanne, is, my wife is 72 years old. She's healthy. She's great. She wants to stay at home. My Parkinson's has gotten to a point where I need to go to an assisted living facility. How is the Medicaid and everything else going to impact our decisions on that?
So the Medicaid applicant, at the time a person applies for Medicaid, the application asks if the applicant has transferred or given away assets for less than fair market value within 5 years prior to the time of application. So oftentimes clients have the goal of passing down their hard-earned money to their children, and they want to do so before they start incurring costs of long-term care. But you have to be very careful, because if you are giving away assets and trying to protect them for long-term care purposes, once you're faced with that actual application, it does ask what the value is of the assets that you've given away. Medicaid, if assets have been given away, the next question on the application is, well, how much? And then Medicaid applies a formula where Medicaid will not allow the applicant to go on Medicaid until a time penalty has been served. And the more that's been given away, the longer the time penalty is going to be. So when working with families, we have to be very, very careful about what the circumstances are. If there is already a healthcare concern in the family, we want to be ultra conservative because we do not want to negatively impact any potential future Medicaid application. So the 5 years can essentially, gifting or giving away assets within 5 years from the time of applying can be extremely detrimental to the applicant. If all of the funds come back, the applicant can then spend those funds without penalty and then reapply after they've spent those funds. But then the problem becomes, how do you get the money back? So during those instances, children may no longer have the funds. Sometimes we use a certain type of trust called an irrevocable trust to kind of park the funds in as a safe place, so that if they're needed due to Medicaid complications, we can tap into those funds potentially. But it's a very challenging area, and I always want my clients to be conservative because the consequences of not being able to receive Medicaid when it's needed can be very severe and very stressful to the family.
I think well put. It's be cautious, but also talk to an expert. Get the information, such as yourself, and really cover that. I'm sure one of the ways we could do that is attending one of your classes in the future.
Yeah.
So I'm going to wrap up. I think we've really touched on a lot of really important issues, things that I know I get questions about a lot from people with Parkinson's disease. Anything I haven't touched on, Joanne, that you really think we should mention, that people should consider before we wrap up today's call?
Yeah, I think that, the topics of estate planning and Medicaid and special needs trusts, it can be overwhelming. And I think that, anyone listening should realize that it's a process and there is a lot of education that goes into the process. As I mentioned earlier, we pride ourselves on explaining the information and helping clients to work through the process. So take it one step at a time and find your way through it and find good professionals to help. Just the fact that you're getting started and taking care of these important needs is really what's most important. We, of course, are always here to help, whether it's through the complimentary workshops or having a consultation with me. I love doing this and educating and getting my clients pointed in the direction that makes sense for them under their scenarios.
Perfect. And what's the phone number again, Joanne, if they want to call you?
Our number is area code 262-347-2820. And again, that's Pewaukee.
I appreciate it, Joanne. Well, really, thank you so much for your time today, providing information and resources on trust, estate planning, and a lot of other legal things people should be considering. So I appreciate you taking the time to do that. We are glad you are checking in with Wisconsin Parkinson Association frequently. We are regularly updating our website and Facebook page with exercise classes, educational videos, such as this one, and a number of other resources you can use to take control of your Parkinson's disease. Please email us at mail@wiparkinson.org with future topics you'd like to see us covered by local experts. Now, hopefully, you'll find these educational video series beneficial to you and your family. WPA relies on donations from individuals like yourself. Please consider a gift today at wiparkinson.org to continue to keep all WPA programs and services free of charge. Thank you again to Joanne for being our guest today. Thank you for joining us. Please take care and have a great day.